Hi, this is Peter Hofer. I'm a senior litigation attorney for Disability Rights Texas, and I'm here with Hannah. Hannah, I'll let you introduce yourself.
Thank you, Peter. This is Hannah Mehta with Protect Texas Fragile Kids, and we are really grateful to have Peter and his expertise with us today to share a little bit more about Medicaid Fair Hearings.
And yeah, today we're going to just talk about what to expect when you're in a Medicaid Fair Hearing. We're going to cover how to prepare for a fair hearing in another episode, but today is really after you've asked for the appeal and you're at the hearing. And so I want to start with some just basic rules so you understand your rights. All the hearings have to be held at a reasonable time, date, or place. Now, most of the hearings, as we'll talk about later, are held on the phone. But when you get your fair hearing notice, if it isn't a reasonable time or date, in other words, if you have a doctor's appointment or you can't get off work that day, you can ask for a different date. And typically, you can ask for one continuance. And when you ask for that continuance, you should ask for, if you have a particular time or date or day of the week that works better for you, you should ask for that. Some other important rights. You have a right to bring witnesses to support your case. You have a right to establish all pertinent or relevant facts. And you have a right to present an argument without any undue interference. So you shouldn't be rushed by the hearing officer or the other side, or you shouldn't be bullied. You have a right to present your case without interruption. You also have a right to question, or as lawyers call it, cross-examine adverse witnesses. Whether you do so or not, or how you do that, we can talk about a little bit later. You also have a right, and this is important, to submit additional documents before, during, or after the hearing. So if something comes up in the hearing and you think, I've got those records, you ask that the record for the hearing be kept open and you can submit them after the hearing.
Peter, I have a follow-up question
Sure.
for you on that. If someone does need to change the time or date of their hearing, will their services continue until that next appointed date?
Yes, so if you are getting continued services because you've asked for the appeal or the fair hearing timely and asked that your services be continued, and those services have a right to be continued, so it's not an initial request for service, then yes, your services continue until the hearing is held and a decision is issued. So typically we see, it takes about a month to get the first setting and a month to get a decision. If you ask for a continuance and it's set another month later, you're looking at 3 or 4 months to get through the hearing process, and your services must be continued by law over that time.
And just a reminder for those who are watching, that is a 10-day period that folks have from the notification of denial to make that request for continuance. Is that correct?
That's correct. It's from the date of the denial or reduction notice. So it may be less than 10 days by the time you get the notice. So you should do it right away. Ask for the appeal. Ask for continued services. And the reason you don't want to wait is you don't want to miss continued services. And if you decide after speaking with your medical professionals that you don't want to appeal, you can always withdraw the appeal. And you can even withdraw the appeal at the hearing. You could call in and say, I don't want the appeal anymore, and it's withdrawn. So don't miss the continued services, because otherwise you're going to go 3 or 4 months without services, even if the hearing officer finds the decision was incorrect.
Thank you. That helps.
So the basics about the fair hearing, they're informal because probably 98% of the hearings are done without attorneys. So they're very informal. They're typically over the phone, and the hearing officer is not a lawyer or a medical professional. It's just a person that's been employed as a hearing officer. The informality goes to there's no rules of evidence, there's no rules of procedure per se. The agency or the health plan has the burden of proof. That's important to know. What that means in legal terms is they have to prove their decision was correct. You don't have to come in and prove you're correct. They have to prove that they were correct by a preponderance of the evidence. And what that means is more likely than not. So sort of 51% supports their decision. I'm not sure how much the hearing officers or the health plans understand, but they carry the burden of proving their decision was correct. It's possible that a health plan attorney will appear. They don't typically do fair hearings, so they don't add very much. Typically, sometimes they just listen in, sometimes they don't show up at all. I imagine in most cases, if there's not an attorney on your side, then an attorney won't be there.
So 2 follow-up questions for you on that, Peter. You mentioned the burden of proof being on the health plan or on the agency, and you said that the fair hearing officer may or may not be completely aware of how that works. Is there a way to incorporate that into your statement or the evidence that you've presented or your verbal appeal to them?
Sometimes in closing, I'll say that they haven't met their burden of proof. They haven't demonstrated that through the evidence that their decision was correct. Or even in the beginning, if I do ask them questions, I'll make sure that they understand that the burden is with them. You know, that could be one of the first questions to the health plan witness. Do you understand that you have the burden of proof in this case and you have to prove your decision was correct? So there's 2 ways to do it. I mean, the hearing officers know that. It's just since they're not lawyers or judges, I'm not really sure how much they understand the weight that burden places on them, but you know, it is what it is, as they say. So
second follow-up question for you, Peter. We have had some families recently who have experienced an overwhelming number of representatives on the other side of the table for the health plan in their fair hearings recently, and sometimes multiple attorneys and other executives with the third-party groups that are making these decisions for the health plan. What would your advice be in a situation like that if there's maybe a parent and a therapist on the other side and, say, 10 people from the health plan on the phone?
Well, first off, the number of people on the other side isn't going to make their decision any better. So, you know, numbers don't necessarily equate to the correct decision. Also, typically, a hearing officer is not going to want to hear from 12 people on their side. There's going to be 1 or 2 key people. Now, when we do hearings, since we are able to cross-examine witnesses, after one of their witnesses goes, we would cross-examine that individual witness. Some hearing officers will allow anyone to answer, which is really improper because you're trying to cross-examine or question that person's testimony. And that's the way it should go. And I always ask the hearing officer, that person testified, I'm asking them questions about their testimony. And some will limit it to that individual. Others will let anyone answer. And I think that's unfair, but if that happens, it happens. But I wouldn't be intimidated. And again, you can go back to, I have a right to present my case without interference, and I have a right to present all the facts. And just don't be intimidated. And I always tell parents, all those people, you could have 40 people in the room, no one knows your child better than you do, and no one knows their medical needs better than you do. So they're at a disadvantage. You're the expert in the room, and so don't be intimidated.
Good advice, Peter. Thank you.
So when you go into the hearing, what should you have with you? Well, you should have the exhibits that the health plan or the agency provided to the hearing officer that the hearing officer provided to you. We call it a fair hearing packet. So it's going to have the denial or reduction notice. It's going to have the submission from the provider for what they were asking for. It may have some rules or policies. It could be anywhere from 40 to 100 pages. That's their evidence packet. You need to have that with you. Any evidence that you send in prior to the hearing, letters of medical necessity, emergency room records, other medical evidence, any information on your child's condition, you should have that evidence with you too. You should have the fair hearing notice because it's going to give you the call-in number, the ID number, so you need that with you. You should have an outline at the very least of what you intend to say so that if you get distracted or they start saying things you didn't expect, you can always look back on your outline and know the points you wanted to make. You should have a notepad so you can take notes. And I'll talk about this later. The way I do it is I have a legal pad and I draw a line down the side and I take notes on what they're saying on the left-hand side, and on the right-hand side I write things that I might want to ask them a question about. Doesn't mean I'm going to, but if they talk for 20 minutes and I've got 6 pages of notes, I need to pick out the 3 or 4 things that were wrong or questionable that I want to think about asking them questions about. I would also suggest bringing in a calendar, your calendar, in case it gets rescheduled because they don't have the evidence or they want more time, or the hearing officer gives you a certain number of days to submit additional evidence, so you need to calendar that.
So a couple follow-up questions on that, Peter. Going back to that first bullet, talking about your exhibits and what you bring with you to that fair hearing. And I know we're going to do a follow-up segment on how to prepare, so there's a little crossover here. But you talked about letters of medical necessity, and you talked about your witnesses and the information you submit. Tell us a little bit more about that, if you would. Who are those letters from? What should they look like?
Okay.
Is a letter better than an individual witness?
Okay. First of all, yes. So letters of medical necessity. Typically, let's say in a nursing case or even in an MDCP denial, they're going to have a medical person there. So if you go in without medical support, you're going to have a tough time convincing the hearing officer that your decision is better than their medical person's. So letters of medical necessity from physicians are very important. One is great, your pediatrician or whoever the sort of main specialist is, but the more the better. So if you have a child that sees 5 specialists routinely and those all affect the nursing services you've requested, however many of those doctors will sign letters of medical necessity for you, the better, because the argument is their associate medical director who's never met your child, their decision is not going to be better than these 4 or 5 doctors that have written letters for you. Now, we're going to provide sort of a template or sample of what our letters look like. Doctors are very busy. It's hard to get them sometimes to write sort of a detailed enough letter. So what we do is we take the medical information from the records and in interviewing the parent, and we make sure the letter is accurate. We run it by the parent, and then we send it to the doctor and say, we've done a draft for you. If you need to revise it, if you're not happy with it, let us know. Otherwise, if this looks good to you and this is your opinion, sign it. Unfortunately, sometimes when doctors write the letters by themselves, they're a few sentences and it's sort of squishy. It would be great if they could have these services. That's really not that helpful. If you get some of those letters, you don't have to submit them as evidence. You can keep them to yourself. The hearing officer's only going to see the evidence you submit. So we usually do a draft of a letter for the doctor and ask them to revise it as necessary and ask them to sign it if that's their medical opinion. Witnesses, that's sort of a longer discussion, but whether you bring a nurse or not, if it's a nursing case, the problem for us is we don't usually get the time to adequately prepare them. We're not sure what they're going to say on cross-examination, or if they're going to have 2 or 3 hours to commit to a hearing, especially if the hearing date keeps changing. So at the very least, I would say get the letters of medical necessity, and of course your nurse could explain in writing why the nursing services you're requesting are needed. But sometimes there are nursing agencies where the nurse is very passionate and has the time and is going to do a better job than the parent in explaining the nursing issue in a nursing case. And so, yes, you can have the nurse come and testify, and they can either have their own outline and do it themselves, or you could question them.
Good to know. Thank you.
So what happens when the hearing starts? You call in, you put in your code, and then the hearing starts. The hearing officer comes on. The health plan representatives are on. The hearing officer typically starts with introductions, who's on the phone, make sure everybody knows who's on the phone. The hearing officer usually gives an overview of the hearing process, what to expect, what we're going to do. Usually gives a statement that the ruling is going to be made on the basis of policy, not law. Hearing officers are told that their authority is restricted to considering whether the health plan followed policy, and that's why the policies are important.
So Peter, follow-up question for you on that. What policy?
Right. And so when you get their evidence packet, you'll see typically they attach some, let's just stay with a nursing case, the nursing policies. And either it's from the Texas Medicaid Provider Procedures Manual, which can be found at the TMHP website, or it's the health plan's nursing policies, or both. One thing sometimes you'll see is they only sort of cherry pick certain policies from the entire nursing policies. And so if you have the time, you should look at all of them and see if there's anything helpful in the rest of them. Sometimes they do the opposite thing, is they give you 40 pages of policies and the denial notice just says it's the nursing policies and doesn't specify which one. And so that might be a question when they're going through, when you have a chance to ask them questions, which policy in particular did you base your decision on? And often they can't point to one.
And Peter, if it seems that there's a conflict, perhaps, between the health plan's policy and, say, the state's policy, What is your advice in that type of situation?
Yeah, and we see that, and certainly we, and in almost all cases, the state's policy, the Medicaid Provider Procedures Manual policy, is the better policy. And health plans are required to conform to those policies. So I certainly make that argument with the state and point out that this is the state's policy. Your policy deviates from that and is causing this reduction or denial, which it should not, and then hope that the hearing officer understands that.
One thing we've seen specific to nursing cases is that sometimes the reductions in service are in direct opposition to what is written into the administrative code.
Yes.
And how would you advise families to deal with that?
Yeah, so the private duty nursing rules that are in the Texas Administrative Code came from a lawsuit called Alberto N. And those rules were negotiated between the parties over a number of years. Those are very strong rules that help people in these fair hearings, and so you should include that in your evidence packet. And again, those are things you can question them on, or you can just point it out in your testimony if you don't want to be confrontational. So when during your testimony, you could say, this nursing rule says this. So in other words, this nursing rule says you're supposed to get nursing over the span of time the needs arise. My child gets 6 G-tube feeds a day between 8 and 8. That's 12 hours. So he's legally entitled to 12 hours of private duty nursing per day. So they violated that rule. The next rule says you can't have parents providing nursing services. Since they're not covering all the G-tube feedings, I'm having to do them. It violates that rule. The rules say you can't reduce services because your child's condition is stable. This plan of care was the same as the one before. They're violating that rule. So you just point out those policies. The more you can talk about policies or rules, that's going to be helpful to the hearing officer. If it sort of gets down to, well, this doctor says that and this doctor says that, it's more of a factual dispute. You should still win that one because your doctor has actually assessed your child and they haven't. But yes, when you can point out that they violated the rules, that's very good evidence.
Do your homework.
Yeah, do your homework. And that statement, do your homework. So these hearings are different than regular trials. In a regular trial, you've done discovery, what we call discovery, and depositions, and you know what everyone's going to say, and it's sort of a show. These hearings, you don't really know who's going to show up. It's not always the person listed on the notice. You don't really know what they're going to say. So by doing your homework and knowing everything that's in their evidence packet and everything that's in yours, then you have a big advantage. Because when their person says, well, the document submitted shows that your child only got 4 G-tube feedings a day, and you know that's wrong, and you can point to the nursing notes in the evidence packet, that's a big advantage. If you're not familiar with the documents and you can't say, that doesn't sound right, but I don't know where it is, you're at a disadvantage. So the real advantage is being more prepared than they are. And you're already starting out ahead because you know more about your child. But if you look through those documents and really highlight the things that are important, and then they deviate from that, you're prepared.
And Peter, what if some of the evidence in the packet is incorrect? What if it's not accurate?
Yeah, again, that's something you point out either through cross-examination, which might be a little intimidating, and also you don't know what they're going to say to that. So you could say, well, this is wrong, and then you get in an argument. You could also just do it in your testimony. I want to point out that this medical statement here is incorrect. It says my child does not have this diagnosis. He does. Because you're a witness, you're testifying, you're providing evidence. So you can do it through your own testimony if you're more comfortable with that.
Good to know.
So let's see. The hearing officer will go through all of the evidence, and this is why hearings can take some time. So they'll have the health plan sort of go through the evidence, the fair hearing packet, sort of like, page 5 through 7 is the denial notice, page 8 through 15 are the nursing policies. So they sort of lay out what's in the hearing packet. They'll ask you to do the same. So you can just sort of say, you can do an index for your evidence and say, pages 1 through 30 is the prior request for nursing services. Page 32 to 42 are letters of medical necessity. So they'll go through that. Then the hearing officer will swear in the witnesses. So you just raise your hand and swear to tell the truth. If you have a witness at the hearing and they're not going to be able to stay for the whole thing, and they need to go at a certain time, to take care of that at the beginning of the hearing. Say, hearing officer, I've got a nurse here that can testify on behalf. They've only got between 2 and 2:30. Can we take them out of order? If if that's okay, and they should grant that. Also, if you did not get the evidence, the fair hearing packet, or any other evidence, then you should raise that at the beginning of the hearing. I never got an evidence packet. I asked for it. I didn't get it. The other thing we'll talk about when we do the second episode on how to prepare is the case file. And the case file is different than the fair hearing packet. Fair hearing packet is the evidence that the health plan wants to use to prove its case. Your child's case file is all of the evidence. And you're entitled to that by law prior to the hearing. They don't just give it to you. They should, in my opinion, but they don't. So one way to get a continuance right off the bat is say, I want a continuance. I just got the hearing notice. I need time to get some additional medical information. I need time to see if a lawyer will take my case, and I'm entitled to my case file. I want my case file. They didn't give me my case file. Because in that case file, so nursing gives a good example. If they give you the denial or reduction, the one that's being challenged at the hearing, let's say you've been approved for nursing, the same amount of nursing, 6 times prior, and your child's condition has not changed, and those requests for nursing services look the same, you would want to use those or submit those to the hearing officer saying, look, every request for services looks the same. Every plan of care looks the same. My child's condition is stable and hasn't changed, and now we have a different result. They can't do that. But you're not going to get that unless you ask for the case file. So you want to ask for the case
parents,
file?
I would imagine, don't know to ask for the case file.
Right. They don't know, but it's by state rule and federal regulation you're entitled to the case file.
Now, what if there are families who get to their fair hearing and they have not received an evidence packet?
Yeah. So at the start of the hearing, when the hearing officer starts the hearing and they go through the introductions and it's your turn to speak, I would say, I think we're going to have to continue this hearing. I never got a fair hearing packet. And they're going to be able to look up in their system and see whether it was generated by the health plan and the hearing officer didn't send it, or the hearing officer never got one. Okay. But do that at the beginning. You don't want to get into the hearing. Now, I've had hearings continued where in the middle of their testimony they referred to some piece of evidence that I didn't have. And I'd say, I don't have that. You didn't give me that. And the hearing officer will grant you a continuance because you're supposed to have it beforehand and you're supposed to have time to consider it. So you shouldn't be having to deal with new evidence during the hearing.
So it's important really to follow along as they're going through
Yes.
that evidence and make sure you are on the same page that they are.
Yes, and that's what we're going to talk about next. So after all the introductions and the swearing in, then they're going to tell the health plan, go ahead and present your case. Now they go first because, as we talked about earlier, they carry the burden of proof. They have to prove they were right. They go first. So what you need to do when they're giving their testimony is pay attention to the person who's testifying. Make sure, so you've already gone through the evidence packet. So if they bring in, Susie Smith and she's testifying about why the denial or reduction was correct, and you think to yourself, I didn't see Susie Smith's name anywhere in that evidence packet. I saw other doctors mentioned or other nurse reviewers, but not Susie Smith. Well, then she really doesn't know much about why the decision was made. They just handed her the file and she's doing the hearing. So first thing, think who's doing this. Is the associate medical director that's testifying, were they involved in the decision, or is it, again, just some person secondhand coming in to read what was written in the notes?
And Peter, if their name is not in that packet, then they typically weren't involved with the decision process. Is that correct?
That's correct. Yeah, you'll see it in the internal notes, the nurse reviewer sort of saying, I don't think this nursing is justified, and then an associate medical director reviews it and might say, agreed. But often those aren't the people who show up. So oftentimes the people that are there just don't really know. They're not adding anything to the documents because they don't know anything more. When they're testifying, sometimes you'll have to prepare yourself with sort of an endless review of non-relevant policies. Like some people just sort of, this is why we did it and this is what we think and it's over. Sometimes they'll read every nursing policy in the manual, whether it has anything to do with the decision or not, and you just sort of have to suffer through it. And so just be prepared for that. The other thing is they had to give you a reason, and typically it's not very clear, but let's say you can sort of ferret out what the reason was in the denial notice. So you want to listen, is that the reason they're sticking with at the hearing? Because what makes a hearing fair or protects you is they have to stay with their decision. So in other words, if they based it on one thing in the notice, they can't come up with a new thing in the hearing. And so I just saw an instance of that, not at a hearing, but recently, where they were denying a piece of equipment saying it wasn't covered. And then that was what was in the notice. Then they tried to claim, well, there was something less costly but equally effective. That's a different reason. You have to stick with the reason that was given in the notice. So you want to listen for that. You want to listen for factual errors, which is going to be easy for you all because you know your children so well. So that's something you'd write on the side, on the right side of your notepad. You know, they said this about my child, that's wrong. They said this about his medical needs, that's wrong. Okay, so listen for factual errors. Listen for the policy or the legal basis for the denial. Do they have one? Are they saying it's this particular policy? And then take notes, and we talked about that, because they're going to be talking. You're probably going to be getting angry about what they're saying. So that's why you've got to take notes and sort of pick out the things you want to talk about based on what they said.
And Peter, a lot of families don't have an attorney to help them with this process. Do you recommend that if they're concerned about maybe getting too emotional in the process, that they have a neutral third party there to help keep track of those things?
Yes, and you're entitled to a legal representative, and it doesn't have to be an attorney. So you could have someone else there with you. They could ask you the questions, or they could take notes and sort of help you. They could point out some things maybe, depending on how well versed they are in the issues and your children.
So they would potentially be allowed to participate in the hearing if you chose or asked them to do so.
Sure. Sure. So that's what's going to happen in their testimony. If you want to cross-examine them or ask them questions, again, you can do that. You don't know what they're going to say. Sometimes there's some people, witnesses for health plans, that they'll talk a lot and not really say anything, and it gets very confusing. So you have to decide whether you want to make your points in your testimony or you want to try and cross-examine them. Some things you could do, you could ask them what was their role in the decision. So that might be where they have to admit, I didn't really have a role in this decision. I just came here for the hearing. That's going to sort of make their testimony look weaker. You could say, doesn't the policy also say that private duty nursing is supposed to prevent frequent hospitalizations? Yes, it says that. It's done that in this case, hasn't it? Yes. So you could do a couple little sort of get in your points that way, but you could also do it through your own testimony. If there's an issue with the notice, there's things in the notice that are incorrect, you could point those out. Point out the factual errors. If they say, the nursing notes say 4 G-tube feedings a day, and you can show them in the notes where it says 6, you can certainly say, do you see that there? It says 6, right? So instead of an open-ended question like, what does it say about G-tube feedings in that note, you want to lead the witness. So what that means is you lead them to the answer you want. So you would say, if you look at the nursing note on page 35, it says there that was the 6 G-tube feeding of the day, doesn't it? So they have sort of to answer in a yes or no way. And you can use letters of medical necessity in cross-examining them. You could say, you can see my neurologist recommended it. I would say probably to use those in your own testimony where you could read them into the record, or talk about, my child has seen this neurologist for 12 years. My neurologist knows my child way better than this doctor I've never met, and this is what the doctor said. So I probably wouldn't use it in cross-examination.
And Peter, have you found one method to be more effective than the other?
I think for parents, I would limit cross-examination because it's more of a lawyer skill, and also you don't know. They could start saying things that are sort of off the wall or talk about policies, and you're not really going to know what to do with it. So I think unless there's sort of concrete factual errors or things you want to point out, does the nursing rule say you can't deny for stability? So it's very simple things. Otherwise, I would just do it in your case.
So stick to what you know.
Yeah, stick to what you know. Now, when it's your time, so when they're done, the hearing officer will say, it's time for the appellant to talk, any representative, so that's your time to testify. You could do it in question and answer, but you're probably going to be there on your own, so you just go ahead and give your testimony. That's where the outline comes in. And you're not going to, when the health plan talks about your child, they're going to talk about, well, they asked for this much nursing, and this is why we denied it. They're not going to paint a picture of your child. That's what you need to do. You need to talk about, this is my child, this is what issues they've had to deal with, These are the health conditions. These are the significance of the health conditions, the severity of the health conditions. You have to paint a background. If you know, there's been lots of surgeries, lots of hospitalizations, none of that's going to come up on their end. They're not going to talk about that.
And I think it's important to remember that the fair hearing officer may not have a medical background, correct?
That's right, and we often use, we ask the parent when we do the questions to explain the condition. So I mean, you can throw out the diagnoses, but the hearing officer is not going to appreciate what that means. So you want to paint a picture of your child and then paint a picture of the needs. Now, you have to remember your audience is the hearing officer. The health plan representative, who probably has no authority to do anything other than testify at that hearing, isn't going to have some eureka moment and say, wow, now that you've testified, we were totally wrong, I approve the service. They're not the audience. The hearing officer is. So you should be polite, be honest, be committed, and then if they ask you questions, which this can happen at the end of your testimony, the hearing officer might have a few questions, or the plan representatives might have some questions. Typically, they're factual. What was the name of the medication your child's taking for seizures? Or I missed that. So things you know. If they do ask you, if the health plan representative starts asking you questions that you don't know, something about nursing policy or the Nursing Practice Act, just say you don't know. I don't know is a good answer. I'm a parent. This is my child. All these doctors say that she needs this nursing. That's what I'm here to do. They've written these letters. Like, again, state what you know. Don't start speculating or guessing. But, you know, I don't know is a perfectly fine answer. Now, if you have a nurse with you to testify and you know what they're going to say, and you know, they didn't want to put it in a letter, or they have a letter and they want to sort of do that, you can do that too. Lawyers can redirect witnesses, and that's a lawyer's skill, but to explain it simply is, if you have a nurse testifying, and let's say they're talking about something and they get the years wrong. They're talking about last year instead of this year, and they just make a mistake. So when they're done and they ask them some questions, you can correct it by saying, I just have a couple questions for the nurse. During your testimony, you were talking about 2016. You meant 2017, right? And they say, right, and you've cleaned it up. But other than sort of cleaning things up, then the nurse is going to be sort of on their own. Now, whether to have a nurse there, it's hard to be super aggressive cross-examining a parent of a child with a disability. It's a lot easier to go after a nurse. So you have to bear that in mind. They're going to go softer on parents than they are on the nurse. So that's why the nurse has to be really committed and really believe in what they're saying and be prepared. You don't want them to sort of start waffling and saying they don't know, and I don't really know about that, okay?
And perhaps something good for families who are watching to know is that a lot of nursing agencies have a managerial person who has experience with fair hearings and understands the process and will often work with you to help represent your child.
Yes. And they can either be supportive in, I mean, typically when they're looking at denying or reducing nursing services, they're in contact with the nursing provider, and then they're providing additional information trying to justify it. And that should end up in the fair hearing packet or in your evidence, because they've already tried to solve the problem. If you do have a nurse testify, there is the sort of office nurse that may be more familiar with fair hearings, but they may not be as familiar with your child and the nursing care. And so that can trip them up in a hearing where they don't really know, whereas you might get the direct care nurse, but they're not as familiar with fair hearings. So there's a lot to consider.
And likewise for therapies and other services, right?
True. So you need to be sure whoever's going to testify for you, you're comfortable that they're going to help you out.
And circling back around on one of the things that you said earlier, I think was a really great point, because we've had some parents who've been in the situation where the health plan will question them. Stick with what you know and don't be afraid to say, I don't know. Don't get into that back and forth with them.
Right. You're not going to win a back and forth with a medical person. I would just keep coming back to, I don't know. I don't know nursing policy, but what I do know is these 6 doctors think my child needs these nursing services. It's been approved in the past. Nothing has changed. There's going to be significant risk if this nursing's taken away. You can bring it back to your child and the effects of the nursing and the benefits of the nursing and the prior history with nursing. So yeah, you don't want to get into a 30-minute dialogue about what the nursing policy is. And all the time, if you don't know, you don't know. If you don't remember, you don't remember. That's just you'll sound better to the hearing officer. You'll sound more truthful when you just say you don't know. So when you're done testifying, the hearing officer, if they have any questions or the health plan has any questions, eventually the hearing will reach its conclusion. Sometimes the hearing officer will keep saying, does anyone have anything else? Does anyone have anything else? And people keep talking. Sometimes you have to know when to quit when you're ahead. If you feel you've done a good job and they've done a bad job, then you need to recognize that. I think things are going well. I just don't want to do any harm here. They might ask if you want to do a closing argument. Closing argument, it's not like on TV. This is over the phone. So if there were 2 or 3 things that you wanted to make sure the hearing officer remembered, so it could be my child's been getting 84 hours of nursing services for 2 years. Her condition has not changed. 4 of her doctors have said she has a medical need for these 84 hours. The doctors for the health plan have never met or assessed my child. Therefore, it's important that these hours be maintained. Something like that. Just a summation of the key points. Or you don't have to do it at all because you will have just testified. So,
but keep it simple.
Keep it simple. Exactly. So typically, in doing this for 20-something years, I've never seen a decision issued at the hearing. They go ahead and take it under advisement. They have to write a hearing decision. It can take anywhere, depending on their deadline, it could be a couple weeks, could be a couple months.
And Peter, just a clarification, because we've had a lot of families ask this after they've gone through a fair hearing. What if they get to the end of that fair hearing and they realize that there was a question raised or an issue raised that perhaps wasn't addressed in their letters of medical necessity, or that they feel like something wasn't covered that was pertinent to the decision?
Yeah, great question. So at the end of the hearing, if the hearing officer doesn't ask about if there's anything else or do you want to keep the record open, you should say, the issue of a swallow study came up. We have one tomorrow. I'd like to have a couple weeks to get the results of that submitted. Or they talked about seizures and there wasn't a seizure log. We have a seizure log. I didn't know that was going to come up. I want to submit that. You do have a right to submit additional evidence, so you just ask for the record to be kept open for a certain period of time, and then you submit that evidence. It's also possible, it's a sort of an uphill battle, but if you were to lose your hearing and you came upon new information that would have changed the outcome of the hearing and you can demonstrate that, you can get your hearing reopened, and the hearing officer has to consider that information. It doesn't happen very often, but if there was some new diagnosis or new finding that would have changed things, had they known that, you could do it that way. So don't expect a hearing decision right away. Typically it's a month or 2, and you'll be getting your services continued the whole time. The other thing to remember, though, is particularly in nursing cases. Now, in an eligibility case, once you're found eligible, you win your hearing, you're going to be eligible till the eligibility process comes around again. But with nursing, because this takes 3 or 4 months, sometimes longer, once you get the decision, you're going to have to resubmit for nursing, win or lose. So if you win and nothing has changed, then you should feel pretty confident that the next request for the same services should be approved. If not, that's a strong case because nothing has changed and they just didn't like the decision and they're sort of ignoring it. But let's say you lose your hearing. If nothing's changed, but you didn't get enough letters or you didn't make a good case or you didn't put on a good show, let's say, you could ask for the more hours again and submit additional information and see if you can get it resolved in the next authorization period. Or if things have changed, I've had hearings go on so long or the appeal process go on so long that when you do resubmit after the decision, the condition is completely different. And so you don't have to ask for the same amount. You could ask for more. You could ask for less. So you have to be aware depending on what the condition is. But you're going to have to resubmit because the 2 months have probably already gone by. So it's but don't be surprised when you have to resubmit right away. So if you lose your hearing, your best bet is probably resubmit with additional information. see if there's some other service that will help you out, see if the doctors can do a better job explaining. Sometimes the pediatrician is signing the request, but really the neurologist is driving the need. So maybe they have to sign the request for nursing, and they can provide more support. You can ask for an administrative review. Basically, that's just an HHSC attorney reviewing the decision. I think only 4% or so are granted. It's really unlikely. You can go ahead and request it. There's no harm in doing it. After that, there's judicial review, but you'd really need an attorney to do that. You won't get your services continued while that's happening, and it can take a year and a half or longer.
You're almost better just to resubmit.
You're better to resubmit, exactly.
And start over.
Exactly. So that's sort of what to expect in a fair hearing, sort of the basics, and then in the next episode we'll talk, probably be a longer episode on how to prepare for the fair hearing if you're going to go it alone.
And Peter, one question to follow up. How will parents be notified of the decision that the hearing officer makes?
Well, it's either mailed. I guess for parents it typically comes in the mail. I've had some parents, the same with notices, the same with fair hearing packets, where they don't get it. If you've gone a couple months and you haven't gotten it, you could inquire. Of course, your provider's going to know, because all of a sudden they're going to have to resubmit. So you'll either hear about it. If you hear that your provider knows one way or the other and you haven't gotten it, you can call your hearing officer. Now, if you're getting continued services, some parents get anxious and they're waiting for the decision. But, the longer it takes for the decision, you're still getting your services, so you shouldn't be in any rush. I wouldn't be calling the hearing officer trying to rush them.
So until that decision is made, those services should continue?
Yes, they must continue by law if you've timely asked for the appeal, and the services can be continued. They have to be continued until the decision issues. So, and if you have problems with that, then that's something you can take to the hearing officer. You can fax in a letter saying, my services are supposed to be continued. They were being continued. Your decision hasn't issued yet, and now they're not continuing them, and that's something they have to take up. So,
thank you, Peter. This has been, I think, very enlightening, and I know there are a lot of families out there who are very grateful for your insights and sharing your experience that will find it very helpful in the days to come.
Thank you.